The considerations that a decision maker is bound to consider or bound to ignore in making the decision are determined by construction of the statute conferring the discretion. Statutes might expressly state the considerations that need to be taken into account or ignored. Otherwise, they must be determined by implication from the subject matter, scope, and the purpose of statute. In Zachariah Wagunza and another office of the Registrar Academic, Kenyatta University, this quote expresses itself as follows, and I quote, concerning relevant considerations, where a body takes account of relevant considerations, any decision arrived at becomes unlawful. Unlawful behavior might be constituted by an outright refusal to consider the relevant matter, a misdirection on a point of law, taking into account some wholly irrelevant or extraneous consideration, and wholly omitting to take into account a relevant consideration. The holding in the locus classicus of Associated Provincial Picture Limited v. Wednesbury best summarizes this principle, particularly in words of Lord Green, that if in the statute conferring discretion there is to be found expressly or by implication matters to which the authority exercising the discretion ought to have regard, then in exercising the discretion they must have regard to those matters. Conversely, if the nature of the subject matter and the general interpretation of the Act make it clear that certain matters would not be germane to the matter in question, they must disregard those matters. And unreasonableness, attention given to extraneous circumstances, disregard of public policy, and things like that has all been referred to as being matters which are relevant for consideration. For instance, a person entrusted with the discretion must direct himself properly in law. He must call upon his own attention to the matters which is bound to consider. He must exclude from consideration matters which are irrelevant to the matter that he has to consider. If he does not obey these rules, he may truly be said, and often is said, to be acting unreasonably. Similarly, you may have something so absurd that no sensible person could ever dream that it would lay within the powers of the authority. It is therefore clear that the only basis upon which the committee allowed the third interested party's complaint was that the ex parte applicant was promoting ideology, interest, and policies of CCU by virtue of the ex parte applicant's name being in the list that was sent to the register of political parties for gazettement. That ground was clearly irrational. If there were other grounds for allowing the complaint, they do not appear in the decision of the committee, and this court cannot surmise as to those other reasons and the weight and impact the committee would have attached to them had they been considered. That's a jurisdiction that is reserved to an appellate court, since this court does not substitute discretion for that of a tribunal. That parties cannot raise issues other than those which were raised before the IEBC committee before this court was appreciated by learned counsel for the respondent, who urged the court to ignore issues of res judicata and jurisdiction as the same were not issues which were raised before the committee. I have, however, found elsewhere in this judgment that an issue going to the jurisdiction can be raised at any stage of the proceedings, even an appeal. Similarly, issues revolving around the coalition agreement and the journey narrated by Mr. Nyamodi cannot be the basis for this court's determination. Mr. Nyamodi appreciated that the most important issue, which was however not dealt with by the IEBC committee, was the issue of party hopping. In my view, if as it is alleged, the issue of party hopping was not dealt with by the committee, then even if it was raised before it, that issue may be presumed to have been dealt with pursuant to explanation 5 to section 7 of the Civil Procedure Act, which provides that any relief claimed in a suit which is not expressly granted by the decree shall for purpose of this section be deemed have been refused. In my mind, if there were other issues which are placed before the committee, it was incumbent upon the committee to identify the same and deal with each one of them. By failing to deal with the same when the matter was before it, the commission cannot purport to now justify the decision of the committee in these proceedings based on the grounds upon which its decision was not based. It is therefore not difficult to understand why the committee could not have found that the ex parte applicant did not cease to be a member of the CCU based on the evidence presented before it, unless the committee decided to go behind the same and investigate whether they were genuine or not, which it did not purport to do. the committee could not reasonably find that the expired applicant had not resigned from CCU party. And this was based on the provision section 14 of the Political Parties Act, which I have reproduced. That provision was subject to the decision of Lenaula J, as it then was, in the case of William Omondi versus IEBC, where he held that, and I quote, "In my view, this provision is clear and requires no more than a literal interpretation. Section 14.3 in effect demands a member of a political party who intends to resign from political party must and is obliged to give a written notice of his resignation to his political party, and if he is a sitting member of parliament, to give written notice to the clerk of the relevant house, and if he is a member of county assembly, to the clerk of the county assembly. That resignation, according to the provision of section 14.2, takes effect upon the same being received by the political party or the clerk of the relevant house. Upon receiving the notice, the political party or the clerk of the relevant house shall then notify the registrar within 3 days of receipt of the resignation. To my mind, therefore, and reading at the provisions of section 14.3 of the Political Parties Act, while section 33 of the Elections Act and article 85 of the Constitution together, section 14 deal with the resignation of a member of a political party from his party. Section 33 of the Elections Act and article 85 of the Constitution deals with eligibility of any person as an independent candidate in an election. The question that then arises is when does time start running for purpose of both article 85 and section 33 aforesaid? To that question, I recall that section 14.2 of the Political Parties Act provides that resignation from political party takes effect upon a written notice being served on the political party. But what is the meaning of taking effect? The Black's Law Dictionary 8th edition defines take effect as follows: to become operative or executed, to be enforced, to go into operation. Applying that definition in the context of this petition, it means that the decision to resign from a political party comes into force and becomes operational the minute the political party receives the written notice of resignation. I've also referred to the decision of Machakos J in Karoli Omondi as a registrar of political parties on the same issue. From the following decision, the expired applicant resignation from CCU was effective from 5th of April 2017. As to whether she lawfully joined Wiper was not an issue that was addressed by the committee. In any case, that issue had been dealt with by the PPDT, which found that as at 30th April 2017, the expired applicant was bona fide member of Wiper. Similarly, as to whether she could, by virtue of being such a member, be validly nominated by Wiper was not dealt with by the committee, and no decisions made by that committee. Since these are not some of the grounds upon which the present application is based, I am barred from dealing with the same as new issues pursuant to Order 53, Rule 41 of the Civil Procedure Rules. It was contended that the expired applicant did not place before this court all the material that was placed before the commission, and that had the same been placed before this court, it would have revealed that there were more issues than the ones which the applicant purported to have been before the committee. Whereas I cannot fault the respondent for responding to these proceedings, as the blame was placed on his doorstep, I have however referred to the provisions of Order 53, Rule 71 of the Civil Procedure Rules. Therefore, the only mandatory requirement is that the applicant lodges the order, warrant, commitment, conviction, inquisition, or record sought to be quashed. In this case, the applicant seeks to quash the decision the respondent made on the 8th of June 2017, which decision has been lodged. In this case, the proceedings which the respondents alleged are missing are its own proceedings. With due respect, there is some level of dishonesty in the position taken by the Commission. If it genuinely and honestly felt that apart from the decisions sought to be quashed, there were other material which would have assisted the court in arriving at a just decision, nothing would have barred it from lodging the same. It is noteworthy that the Commission instead decided to lodge, and I dare say so inappropriately, an electronic document allegedly containing the list of members of the Wiper Party, which was not even part of the record of the proceedings before it, while omitting what was in its view crucial material which was placed before it. As a judicial tribunal, the respondent tribunal committee is expected pursuant to the national values and principles of governance in Article 10 of the Constitution, to be transparent and accountable in its dealings with candidates and the court. It is therefore improper for it to keep its own record from a court and contend that there was some material that was placed before it that is omitted from the record before the court. In my view, as a judicial organ, the Respondents Tribunal owes a much higher duty of disclosure than the ex parte applicant when it comes to administration of justice, taking into account its role not only in electoral disputes but in the electoral system as a whole. The third interested party contended that the likely consequences, if the court were to agree with the applicant, would be to reopen the race for all those that were validly rejected on similar grounds, would probably run into hundreds and eventually affect the entire elections timelines and calendar. However, I wish to associate myself with the case of Jacqueline Resley versus City Council of Nairobi, where it was held, and I quote, "The purpose of the court is to ensure that the decision-making process is done fairly and justly to all parties. That the law must be followed is not a choice, and the court must ensure that it is so followed, and the respondent's statements that the court's role is only supervisory will not be accepted, and neither will the view that the court will usurp the functions of the evaluation court in determining the matter. The court is one of inherent and unlimited jurisdiction, and it is its duty to ensure that the law is followed. If a local authority does not fulfill the requirements of the law, the court will see that it does fulfill them, and it will not listen readily to suggestions of chaos. And even if the chaos should be solved, still the law must be obeyed. It is imperative that the procedure laid down in relevant statutes should be properly observed. Provisions of statutes in this respect are supposed to provide safeguards for Her Majesty's subjects. Public bodies and ministers must be compelled to observe the law, and it is essential that bureaucracy should be kept in its place." Unquote. In my view, what the court was saying is that the public interest plays no part in my view, what the court was saying is not that the public interest plays no part in enforcing the law, but the courts will not shirk from their constitutional mandate of ensuring that the law is followed. It's now tried that contravention of the constitution of the statute cannot be justified on a plea of public interest, as public interest is best served by enforcing the constitution and statute, as was held in the Public First County Government of Mombasa ex parte Outdoor Advertising Association of Kenya. I've also relied the case of Musalu and others versus the Attorney General, that the Constitution has to be given generous rather than a legalistic interpretation aimed at fulfilling the purpose of the guarantee and securing individuals full benefit of the instrument. A judge has to pass between the government and the man whom the government is prosecuting, between the most powerful individual in the community and the poorest and the most unpopular. It is of the last importance that in the exercise of these duties he should observe utmost fairness. The judicial department comes home in its effect to every man's side. It passes on his property, his reputation, his life, his all. It is to the last degree important that he should be rendered perfectly and completely independent, with nothing to influence or control him but God and his conscience. The greatest scourge and angry heaven ever inflicted upon an ungrateful and sinning people was an ignorant, a corrupt, and a dependent judiciary. Unquote. To the foregoing, I would add a timid and spineless judiciary. In Riverside versus Anderson, Lord Atkin held that in this country, amid the clash of arms, the laws are not silent. They may be changed, but they speak the same language in war as in peace. It has always been one of the pillars of freedom, one of the principles of liberty, for which on recent authority we are now fighting, that judges are no respecters of persons and stand between the subject and any attempted encroachment on this liberty by the executive, alert to see that any coercive action is justified in law. Unquote. The purpose of judicial review is to check that public bodies do not exceed their jurisdiction and carry out their duties in a manner that is detrimental to the public at large. It is a controlled supervision of public authorities involving a challenge to the legal validity of the decision in question. In this case, however, the issue of floodgates being opened by this decision does not arise, since the only ground upon which the third interested party's complaint was allowed, being the existence of the order in miscellaneous application 67 of 2017, cannot be said to be common in those other proceedings alluded to by the third interested party. In this case, the court has found that the other issues raised before this court as the basis for justification of the committee's decision were not grounds upon which the committee made its decision. The ground upon which it did so was as a result of consideration of an irrelevant factor, hence the decision was irrational and, as usually put, Wednesbury unreasonable. It may well be that the committee based its decision on issues. It may well be that had the committee based its decision on the issues now raised before me, a different outcome might have been reached, but that is not the matter before me, and I cannot speculate on the same. I therefore do not see how the outcome of this application will affect any other matter as alleged by the third interested party, which matters this court is not privy to. It's, however, my view. I find that the only basis upon which the IEBC Dispute Resolution Committee arrived at the decision of the 8th of June 2017 cannot stand legal scrutiny. It was, with due respect, hopelessly unreasonable. In the premises, this motion succeeds, and consequently I issue the following order. I issue an order of certiorari removing this court for purpose of being quashed the decision of the Response Tribunal made on 8 June 2017 in Complaint 79 of 2017. That decision is hereby quashed. I leave an order of prohibition prohibiting the respondent from implementing the same decision. I also issue an order of mandamus compelling the respondent to include the name of the party applicant as the Wiper Movement political party nominee for Machakos County Gubernatorial elections, which are scheduled for 8th October 2017. I have agonized whether, in the circumstances of this case, I ought to award costs. As submitted by Mr. Nzamba Kitunga, the respondent herein still has the mandate of presiding over the elections in which the party applicant intends to be a candidate. On the other hand, the third interested party herein has maintained that he is a member of the vehicle the party applicant has boarded towards her political destination. In the spirit of promoting reconciliation, it is my view, and I direct that each party will bear on course of these proceedings. Those shall be the orders of this court.
I was just saying much obliged, but may the record show that I and Mr. Paul can wait.
Spoke about some. The motion applying for the judgment by law. We would ask for a certified copy of the judgment.
An emotional Wavinya Ndeti at the High Court, presided by Justice George Odunga, after she was allowed to run for the Machakos Gubernatorial seat. Wavinya Ndeti was in court after the IEBC Dispute Tribunal decided to nullify her nomination in the Wiper Party to run for the Machakos gubernatorial race, contending that she had not resigned from her CCM party by the time she was being awarded the ticket by Wiper. And those are live pictures from the court right now. Visibly very emotional Wavinya Ndeti after that pronouncement. The court is filled by her supporters, and in jubilation they're celebrating this great feat. Yesterday I was at a forum, a political rally hosted by NASA in Kitengela, where one of the principals of NASA said that this must come to pass because Wavinya had duly resigned from her party by the time she was being given the Wiper ticket, and we had a copy of that later, almost immediately, showing that he had resigned on 4th, but it was received by the IEBC, by the Register of Political Parties, a day later. So the question again that the court was addressing there, had she validly resigned? So it was the difference between the day of submission and the day that it was signed. So finally, it's come to pass that Wavinya Ndeti will be facing Machakos Governor Alfred Mutua in the race. So those are live pictures. Jonathan Mweke is also there at the court, and most of those supporters of Wavinya Ndeti, you can hear the celebrations and the jubilation. Well, this is just one of the stories that we are following up for you. The live pictures are the top from the court.